Can we start?
Yes, Chair. We're ready.
Please.
Okay.
But Justice, I'll wait for Justice to first go ahead.
Okay. Advocate Kosana?
Thank you, Honorable Chair and honorable members. And we'll see again years back on camera. We're supposed to him to switch off, and I'm sure we will do that again. I'm going to ask that we be firstly on the queue. It will be Mr. Nicholas Monyai. Mr. Nicholas Monyai is also by way of introduction. He has just joined the department from AMSCO in terms of the IJS program. So I want him to share in terms of governance framework, but also to introduce himself and say what is the approach going to be. It's going to be followed by the Solicitor Acting SG, Solicitor General. Then thereafter we've got the IT and court services, but I'll call them as they come.
Thank you, Honorable Chairperson of the Portfolio Committee and honorable members of Parliament. My name is Nicholas Gongoro Munyai. I have recently joined the Department of Justice on a secondment basis as a head of integrated justice system. There were two questions raised relating to the IJS. One by Honorable Mohammed, who was asking whether we could send the governance framework that we're currently working on. You would understand that there's been a lot of complaints around the governance model being followed in the implementation of integrated justice system. So what we are introducing in the document that we'll be presenting to the EXCO, the departmental EXCO on Monday, before it goes to the minister to serve in cabinet. So it's the three levels of governance. One, we would recall that we have always had what we call IJS board, which was mainly constituted by government information technology officers and business representatives of all the cluster criminal justice system related departments. So what we are introducing now to enforce accountability is that we have seen that the forum on its own at the level of GTOS and the business representatives finding it difficult to manage the program without the oversight of the upper level, which is the second level, which we are going to call the IJS DG's Oversight Forum. In that forum, all the DGs, the DG of Home Affairs, the DG of Correctional Services, the DG of Police, and also the CEO of CETA, and will also be convened or chaired by the DG of Justice, that they will be taking oversight responsibility. They will be also be responsible for approving all the business cases that will be coming from all the respective departments, and also keep the monitoring together with the board of the IJS, which will be the lower level board. And that on top of the DG's oversight committee, there will be ministerial committees response of the ministers in the criminal justice system. But again, on the implementation part, the lowest level, which is of GTOS and business representatives, we are also extending to the Department of Defense and State Security to have GTOS and business representatives on an ex-official basis for knowledge exchange purposes. We will be sharing the document immediately after it has served in EXCO and also been dealt with as gone to cabinet. Wasn't that memo we have indicated also on the approach we are going to take in the digitization approach.
Thank you, Chair. We'll now get to the SG. Just also to introduce himself and then comment on the State Attorney's Office.
Afternoon, Chairperson, and thanks for according me the opportunity to introduce myself. I greet all the members. The question that has been posed to the Office of the Solicitor General is just one. My name is Pejisani Ronald Panderani, the Acting Solicitor General. The one question that has been posed to the Office of the Solicitor General, and that came from member Isham Mohammed, and that had to do with the briefing patterns, more particularly briefs that goes to PDIs.
SJ, we want to see you. Can you make your video to be on?
Yes. All right. Yes. That's the face behind the voice. The question that I'm actually requested to reply to has been asked by member Isham Mohammed about the briefing and how do we get around the issue of client departments in fact interfering with the briefing and whether there are any policies in place to get around that issue. I think members would be aware that the State Attorneys Act, as amended, has decentralized the offices from one central office to 30, and that is the same act that in fact introduces the Office of the Solicitor General. And for that reason, it is important that we deal with the issue that has been raised by the member. More to the point, and just to give a brief synopsis, the clients are in fact allowed to recommend, but that recommendation in itself is not decisive. There is a need to interact with the state attorney that is actually supposed to be dealing with the matter, and there will be a call for quotes. There is also a briefing committee in each office of the state attorney that determines the suitability of counsel to be appointed. But during this COVID period, there will also be a directive to all offices of state attorney, where the Solicitor General will also be a part of, which will also deal with issues of briefing, so that we can, in fact, eliminate the aspects that the member had highlighted and eliminate the risk of interferences. The policies to be implemented or the procedures to be implemented will decide that we need to eliminate all of the other aspects that have been identified. There are 5 policies that in fact have been highlighted in the slides. They are not yet tabled before Parliament, and pending tabling of those policies before Parliament, we will or on the 13 state attorneys' offices or heads of state attorneys with the oversight of the Solicitor General will be hands-on in relation to briefing of counsels to eliminate the dangers or inherent dangers that the member has identified. Thank you.
Thank you, SG. I noticed that Mr. Munyai's camera was off. I just wanted to show face, but Mr. Malema will give an answer for court services.
No, that's me, Mr. Nicholas, Honorable Chair.
Mr. Malema, court services.
Good morning, good afternoon, yes. Good afternoon, members, and thanks for the opportunity. I'll try and deal with some of the questions that have been raised for court services, and the other colleagues will also come in to support at a later stage. On maintenance, maybe if we start there. Indeed, during the lockdown, we've experienced some problems with payment of maintenance. This is the first time that we've experienced this problem in respect of payment of maintenance beneficiaries. And the problem is largely bigger in the Eastern Cape, we're aware, but it really emanates from basically 3 areas. We've had some system challenges. I think some members mentioned the system that has collapsed at one time, and IT is dealing with it, and they will provide a response in that respect. The second part had to deal with the system of Moja itself, and Mr. Johnson has dealt with that with the service provider. The system has been. We've been able to specifically for purposes of, we've been able to rescue that, and we've been able to do the payment for maintenance. And then the third problem with maintenance really relates to the courts themselves, where sometimes the clerks and security do not give people to the court. So we've issued instructions that, in this level, maintenance services are allowed even in level 5. They were allowed, and these are critical services for very vulnerable people, so they shouldn't be turned away. And the last problem really around maintenance relates to the fact that a lot of people were not paid by the employers, because the employers are not generating income, and as a result of that, they've not been paid. But I think sometimes some of the beneficiaries don't understand that the problem could be coming from that direction, and they think it is coming from the court. So in general, we pay about 53 million monthly over Moja. And as I said, we've been able to rescue the Moja module. And Mr. Johnson will come in later to give you more details on that. With respect to the victim-centric approach, we believe that we should give victims greater emphasis. The criminal justice system has been accused by many people that it tends to be friendly towards the accused persons, the offenders, but it is not very friendly towards victims of crime. And this is why we have decided to develop a strategy, a document. So for the current financial year, that is the plan that we're having there. First, we would like to develop a draft discussion document, which our unit in vulnerable groups will lead, and that will be the basis of our discussion with all the role players. But effectively, what we're looking at, it's a system that will actually be speaking also to the sexual offences court that will be designated. So we'll be looking at the facilities themselves. Because when the courts were constructed, issues of human rights, this is long ago when the court went, issues of human rights, human dignity, charity, they were not taken into account. So in the new era, we need to take into account the ethos of the Constitution and ensure that the courts speak to, those fundamental rights. So that's what will be happening, but it's more at a discussion document that will be consulted upon. But we continue to, at a facilities level, once we're developing a discussion document, continue to effect the changes. So we're not going to wait for the document to be finalized before we deal with the problem. So things relating to procurement of, furniture, as an example, for both staff members as well as the members of the public that are coming to court, we continue to procure those, and so that our people that are coming to court can have a measure of dignity and they can be treated with respect. And so the member that raised the issues around the benches and all that, if you go to some of the courts, and I consider that it's not all the courts, but it's something that is a focus that we are determined to ensure that the courts are actually victim-centric, friendly, and people are, can go to a place that respect. And when it comes to the backlogs, We actually commenced with the project to deal with the project during the course of this week, and this was initiated by the Deputy Minister yesterday and day before. On Wednesday, we had a meeting with the Chief Magistrate yesterday, and on Wednesday we had another meeting with the Regional Court President, in which we were all discussing the current challenges of how we're going to deal with the current backlogs that are emanating directly from the lockdown. And so we will have a two-pronged approach that deals with how we raise, the backlogs that are accumulating as a result of the many postponements that are taking place. And indeed, I think the members will appreciate that because we are still under level 4, we have very limited movement in terms of the things that we can deal with in the courts. But we'll also deal with the classical backlogs that we've accumulated over time. So in short, we've created a structure as the rapid the risk adjusted strategy, the RAP that we've developed as a department. We've created a forum inclusive of all the stakeholders. We've got their input, and we're busy developing the terms of reference that will guide us in terms of the work that we'll be doing. There was a question on access to people with disabilities in terms of how we are supporting them and the use of sign languages. We do not have on our staff establishment interpreters for sign languages, but we've got databases for every region, for all the courts. We've got access to databases of either individuals or service providers that provide services for sign languages. And so we certainly go out of our way to ensure that we provide those services. But in addition, we are working with various NGOs in respect of ensuring that we understand how the sign language community works, because there are different cultures, and we ensure that the people that claim that they can interpret are people that are credible and they're able to interpret. So my colleagues in facilities will also deal with a project that we are running together with Public Works that continues to do modifications in the various courts in respect of providing the rails, modifying ablution facilities, to ensure that we are sensitive to the needs of people with this. In respect of domestic violence, we have seen again during this period, quite a number of domestic violence cases that have come. We go out of our way to listen to those matters. The judicial officers have and continue to be trained on social context training, which gives them a sense of sensitivity around those issues, so that when they approach these matters, they approach them with a measure of sensitivity. Indeed, we may have some courts where, because of space limitations, we are unable to provide the necessary privacy that is required. But in general, when that happens, the people that are sharing an office will then package so that we provide comfort to the person that is coming to lodge a complaint. And I can imagine that during the COVID a period where we must exercise social distancing, that our problems in the court are going to be compounded because we did not have space, but now we must comply with 1.5 distance between people. That this is going to create a challenge, but certainly will ensure that the respect that must be accorded to people that are coming to make DV matters is actually upheld. I will then also deal with AVR, and my colleague from IT will add on to that. In the sense of AVR, we've got various sign sites, 47 sites that we have deployed, and we will give you an explanation in respect of why we are, the numbers that we are adding, they look like they're small, but they're actually not small. But Mr. Naita will give you a sense of how that goes. If I were to give you the totals of the utilization of the ADR system since the period of the lockdown, the province, I'll not go through the state of the province, but we have them available. We can finish them. I'll just give you the totals. From the period of the 6th to the 9th of April, we dealt with 1,092 cases where postponements were done through ADR. In the period of the 14th to the 17th of April, we dealt with 2,040. In the period of 20 to 24 April, we dealt with 1,863 cases. And at the end of the month, the days 28 to 30 April, we dealt with 957 cases. And then in the following month, in May, from 4 to 7, May, we dealt with 2,003 cases. And then the following week, which was 11 to the 14th, we dealt with 2,040. And during the course of we dealt with 347. So in total, we've dealt with 10,340 cases through the ADR system. There are courts and correctional services, very few of them where there are some system challenges, largely I think one or two in the Eastern Cape, but we continue to work with correctional services. In fact, interestingly, last week we had a meeting. Today we're supposed to have another meeting with correctional services, but we had to postpone it because there was a portfolio meeting. So we've set up a meeting that is made up of justice together with correctional services. The minister has said that we need to work very closely, and I can give him the comfort that we have set up various committees in which the Department of Justice together with correctional services are working together. So in respect of the AVR one, we met last week, in which we are beginning to look at the new sites that we need to roll over, but we also dealt with issues around, the assets themselves, because originally we were procuring and funding the entire project. So we're trying to clean up the issues that, the equipment that is in the correctional services, we must offload from the asset register of the department so that it gets into the asset register of correctional services. We dealt with issues around the budget, around how we're going to allocate the budget. The budget is still on us. So the sites that will be rolling out for the current financial year, we will procure for those sites, and we'll also deal with maintenance. So I can assure members that, we are dealing with those matters very sensitively. As I said, we have dealt with the issues on Moja Pay. On the courts, on the number of sexual offences courts that actually, it's not the numbers only that we're changing. The section that speaks to the new site that we need to designate lays out quite a number of issues that needs to be there. The number of personnel, the training, the facilities, the AVR system, the intermediaries that must be there, the systems in the intermediaries. So it's not just the numbers that are there. The numbers are important, but the section that speaks to the what is the courts and needs to look like, the quality, as the member said, it's something that we're pursuing. So we're looking at both the quantity so that there is access, but also the quality so that, whatever we're doing in those courts, the people are. And on the foreign language interpreters, indeed, we during the course of last week and this week, we've been in discussions with correctional services. We've been informed that they actually have a tender in which, they have a service provider that sources for them. So we're in discussions with them to understand how that process works. They've furnished us with some documents. We'll be meetings with them to actually begin to understand and to see whether they've got a good system, and whether the system we can leverage on that. And I think here, members, what we need to be doing as government is to have a unified approach in respect of how we deal with foreign language interpreters, because our experience is that they're exploiting government by going to a department that offers bad rates. So if justice pays 100 rands per hour and subs pays 200 rands per hour, they then dump the Department of Justice and goes to subs. But what we need to do as government department is to actually have a uniform approach in terms of the tariffs, so that we have standard tariffs, whether they go to health or they go to DSD or they go to Home Affairs, the tariffs are the same, so that we don't have the system being played. And I think that's what has been happening, and this is why we've started the discussions with Home Affairs. And once we've dealt with this, we'll approach the DPSA so that we have uniform tariffs together, approach Treasury so that we have uniform tariffs around this. But also in terms of the technology, we would like to move away from the system where the FLIs are called and they travel and we have to pay them huge amounts in traveling and we have to house them as well for sleeping over. So as part of our discussions with ISM, as part of AVR as well, we would actually like to use AVR to actually bring foreign language interpreters to use that system. So this will cut down the cost of their traveling and the cost of accommodation that we're paying. So we are very excited about that project because it will really assist us. And I'd like to get to the conclusion around the PPEs. When we started with the lockdown, we really struggled with the procurement of the PPEs. But as we moved on, we really accelerated and improved. And so you will hear that there are very few complaints that are coming from the courts where there are no PPEs. We procured PPEs. So our approach has been to procure at 3 different levels. First, at the court level, where there is a court manager or an office manager. We provided the necessary delegations for procurement, and we've also increased the amount with which the court manager can procure for petty cash, so that when they run out of soap and the kind of things that they can go across and procure, we put in the delegations. And at the third level, we procure it at the regional office. The regional head has delegations up to 500,000. There is a committee called the RCC, the Regional Procurement Committee, so they procure it. At the third, we're procuring at the national office. At the national office, the delegations, they are huge. And in fact, last month, we did procurement for the whole country, and we procured in such a way that we have enough stock. And that's why you're not hearing about the problems of procurement. But in addition to that, we have deployed a tool. The tool is actually being used.
Sorry, sir.
Deployed a tool.
Sorry, sir.
Yes, sir.
There are people who have not muted
okay.
the mic, and they are busy.
Our apologies. We did ask them to. There were some colleagues that were consulting on something. Apologies on that. But we also asked the other colleagues that are in the regions to actually mute their mics and their videos. So I was saying, Chairperson, in conclusion, that we've also deployed a daily monitoring tool that asks each site about the PPEs in respect of your sanitizers, in respect of your soap and that kind of thing. So we believe that the deployment of the tool will also assist us to deal with the non-availability of the PPEs. So I will pause at this stage and allow the other colleagues to take over. Thank you.
Thanks, Chair. We're just going to get a brief remark from the acting DDG for HR in terms of the vacancy. We'll then get to the acting Chief Master, and then I will run off all the outstanding questions after the Chief.
Good afternoon, Chair and honorable members.
Sitting in front of you here is Donald Kumfolo, one of the experts in DG Corporate Services. On the question as to how come we let the vacancy rate at SMS level go this high, even previously, we alluded to the fact that we had a post-review committee process based on the Treasury instruction to cap our wage bill. And to that end, for close to 2 years, we had to go and rationalize and reprioritize all our posts. But if I have to do what I call a faulty analysis, there are compounding factors. In the process, we had various transitions within the department, unfortunately, where the first DG had to leave and then we had to get DG Matonzela. And during that process, the structure, you see, and I think the acting DG alluded to that, we were also busy with the structure, and I'll come to the resolution part. Then later, we got into the transition period for the fifth administration, going to the sixth administration. So meaning that a lot of SMS vacancies had to be put on hold, while also we're dealing with the 3 tiers in terms of the DPSA resolution. However, and that's why you will see maybe when we give you written responses, that for levels below SMS level, we started gradually filling them to give capacity, because we were just faced with those particular challenges. Then we started to
sorry, sir.
capacity at the level.
So can you switch off your video? I think it will improve your audio.
Yeah, thank you very much. So we created capacity at the lower level, and then we transited to the senior management level. Now, as the APDG has alluded to show that the training platform, all of us who are acting, including myself, as we speak, all are acting, almost most of us, will be ending by the end of June. But the other component factor, the first 3 analysis that I spoke about, is that during that period, in terms of your human resource plan, a lot of colleagues, especially the expo level, were about to retire. I think 40% got other opportunities during the transfer. However, the AKDG has already appointed someone to assist us in terms of ensuring that the shortlisting process has started, like DG Corporate Services Post. This week, the process has already started, and all others, depending on availability, of course, of the minister and the other panel members, given the fact that they are also involved at the COVID, with the COVID issue at the highest level. And the structure, we have already appointed a company that's going to assist us, and we are also partners. The acting DG will add where I left off. Thanks very much.
Chair, before I run off, there was a question on the paperless masters, which was asked, but I'm sure the Chief Master will still recollect their thoughts on it. But let me give an overview of those unanswered questions, Chair. Just briefly, just round them off, so that it can allow MTA the opportunity as well to give that views. There was a question on the GBV. When are we going to start the council, whatever? And I think the DM will round off on that one, because it's also been assigned the responsibility around the gender-based violence. The LDR can also just add that the figures that are on the 8 over the next MTF are going to be supplemented or revised in light of the plan of action we are preparing for the implementation of the risk-adjusted plan. And that is part of the COVID-19 legacy project is coming through. And we're going to share with the members what the new figures are going to be around there. And I'm sure, although there's been cuts in certain areas, I think the message is very clear that what will be prioritized from the remainder of the budget that we're going to have is all those programs which are intended to prevent and curb the spread of COVID-19. And AVR and some of the modernization programs are basically meant to facilitate less contact amongst people so that we can basically leverage as part of that. So the NDP is going to a point that at the cluster level, the cluster has been asked to identify some of the recovery plans that the cluster wants to put forward for purpose of this representation, and the IJS and some of the modernization programs are part of the process. So our program in terms of migrating into the online services will basically be informed by that plan. I must just say that Minister asked that we get a plan to him by the end of this month, and we have already started to work on it, and they were taking lessons from various departments, SARS being one of them, and the commissioner is part of the panel engaging with at the DG's forum, where I've been able to leverage on a number of benchmarks that we can take from them. Mr. President has also raised the issue of the inability to pay bail at the police station because of the system the DCS has implemented that stop the acceptance of cash. We are also we're in discussion with the DCS because we also want to stop the payment of cash in the courts, because cash, the exchange of cash is also one of the risk areas in terms of COVID-19, and we are looking at various options. One of which is to procure our Bitcoin so that we can also work smart payment of fines, whatever can happen through cards, and save people from carrying heavy cash to come and pay fines. In fact, one of the best leverage of this program is that we are also stopping a security company that was engaged simply to take cash and court fines from the court to the banks. We realize that basically the amount we pay to those companies, those commensurate with what we collect. We can't pay coin security company 87,000 rand to come and collect 6,000 rand paid for bail per day, etc. So all those things are going to be regulated as part of COVID-19. Whilst I'm at that point, I want to respond to Mr. Horn's comment that there's apparently information that a contract involving the SASA was stopped and rewarded and rewarded again after certain investment happened. That information is not correct. The information we have before, and in respect of which some of the colleagues will be facing disciplinary action, relates to PFMA transgression, but also relates to certain aspects that were raised before the State Capture Commission, which will basically be verified out of as part of the process, which I will not diverge on now because that will be part of the evidence moving forward. Now, on the matters raised by Honorable Member Masego Chene, and I've got 4 questions, all of them which wanted to get assurance how we're going to stop the network interruption and how we're going to make sure that it does not happen again. And same, Honorable Swart, I reiterated that one of the COVID-19 measures has been that we need to make sure that we build and invest on our IT environment. I think we have not paid so much attention to that. So we are building disaster and recovery management plan so that when system crashes, because some of the things cannot, we should be able to recover them within the shortest space of time, not wait for a week or so to recover merger pay and whatever system. And I think as well as building maintenance plan around the systems, we must not wait them to collapse. We must continue maintaining them, and those are part of the building plan. But this morning I told colleagues, we don't only end with an apology to the beneficiaries of those services. We are going beyond that. I've said, as part of our online services and the modernization program, by the end of June, in line with the moving towards submission papers. We need to have put into space the SMS system that tests all beneficiaries of guardian funds and maintenance, not only when there's crashes, to tell them that the money has been deposited in the bank where the deposit does not happen before they go to court, so that we can apologize and put measures in place to correct those aspects that come from motor pay, etc. And colleagues have tried to work on that. One of the delay part was that we did not have all the same numbers, etc. And we are collecting that per court, per side, so that at least in 2 months' time we are able to communicate with our clients. And we say the next level of expansion of services will be towards the people who come to court, who are witnesses, who are vulnerable persons, whatever, so that they get reminded by SMS. In fact, we should be moving away from the system where we're going to send a sheriff driving a 3x3 basket to go and serve a summons. When you can basically invite those people by use of technology and more effectively and efficiently and quickly. And those are part of the legacy project we're going to look into, etc. We have noted Mr. Suarez's concern around the budget cut. I must say that obviously the budget was allocated by November. We only had those cuts which were part of the process. So the COVID-19 have basically further overstretched the budget. That's why we are praying and hoping that we pass this pandemic as soon as possible, so that we can the economy can start to grow and we can basically be able to move forward, etc. I must say, Honorable Janji, I basically got impressed by the presentation by the NPA in terms of its turnaround plan as well as the risk register, and we are going to learn from it. We basically, as part of our turnaround plan, also take the very same approach, so that we will basically identify all the risks and mitigate them as we move along, so that the committee is going to be able to know where we are. The risk plan was impacted by COVID-19, but I must say that we were not even if there was no COVID-19, we were not going to get a clean audit by the end of this financial year. That fourth quarter report already shows that the capacity challenges that are banded to, the misaligned structure that are banded to, and the systems challenges that we have talked about are part of the contributing factors towards our performance and our accountability arrangement. And as we invest in those aspects, we'll also be able to draw back on those deficiencies as we move forward, etc. And I think I've covered the balance of the questions which were not covered by colleagues. And I'm going to leave. And I've noted, Mr. Janji, that we need to strengthen our performance targets, basically to bring in more quality outcomes than basically reflect on numbers, etc. And that's the point that the Deputy Minister have raised over the time, etc. The question which was raised on the paperless was, firstly, how do you make sure that the introduction of paperless systems in the masters does not disadvantage the previously disadvantaged people in view of their opportunities to use the online services. And I think we have taken note of that. We'll make sure that we are not in the process, just like what has been happening with COVID-19, when the online education seems to disadvantage those who don't have the opportunities and the benefit of those systems. We'll make sure that we don't basically lock down the system. We still run manuals for some time until such time that the council as a whole has basically migrated and have basically coming into the party in terms of the broader modernization program. Now, Chair, they've talked about the issue of vacancies. I'm not going to allude to. Safe to say that last week, not early this week, Monday, Public Safety and Administration issued a circular to departments to identify all the critical vacancies which are required in terms of permitted service under level 4 lockdown to be advertised. We are finalizing our list. We are going to be cleaned up by ExCon Monday to make sure we don't miss any point. They will be advertised by the next coming weekend or soon thereafter, so that we can use the opportunity to move on. That includes the position of Chief State Law Advisor, the position of the regional head, the positions of the head of state legal services have been advertised, and the closing date was affected by COVID-19. We'll start the process of filling them. Only those posts which the closing date happened during the lockdown we've been instructed to advertise them so it can basically invent the way so that we don't disadvantage those who could not have had the opportunity to file their application during the time. I will leave this the last opportunity, the Minister to round off, but obviously there are further questions that there's still further clarity will remain available to submit on in written form or also become being guided by the chairman. Thank you, Honourable Chair and Honourable Members.
I was out offline for some time. I'm not sure whether the issue of the Zondo Commission was responded to.
Chair, no, my apologies. Let me respond to it quickly. We met with the Commission day before yesterday on Wednesday with the National Treasury, the acting secretary of the Commission, and the head of the investigation, started by the head of the investigation and the legal chief, that they have used the lockdown and the slowdown in terms of the state of disaster to navigate through the massive evidence we have received. So the investigators and the legal team have continued to work behind the scenes because we threatened that if there was not going to be any work happening, we will not honor any invoice to pay, and that threat has also helped to keep them on the toes. So work is happening, and we've been assured that the investigation will still complete will be concluded by the end of August. Only the hearings will then happen September, October. So we're guided that by that time, I'm sure the level 3 lockdown will allow certain levels of hearings to continue. And we confirmed an allocated letter to them, which I signed yesterday, and which the minister signed a letter to a chairperson. We were able to give them an allocation of 150 million for this financial year against the allocation of 214 million they've asked. And obviously that was an allocation informed by what we have in the treaty, and we have created an opportunity that we will continue to engage should there be a need to adjust and move around the budget for them to be able to not to be hamstrung by the budget challenges. Their work continues, and we are very comfortable that are continuing. Thanks.
Honourable John Jeffrey.
Thanks, Chair. Just maybe to add a few points. Firstly, on the gender-based violence issues, the lead ministry on that is Ministry of Women. So that the Cabinet has agreed on the establishment of a gender-based violence council. There is an interministerial committee on gender-based violence that the Minister of Women chairs. And so that process is moving, although I think it was a bit affected by the lockdown. Just on other questions on gender-based violence, while this meeting was going on, the Minister of Police was releasing statistics for the lockdown period on crimes in general and gender-based violence as well. And there's been a significant reduction in the murder rate, for example, 63.9% reduction, attempted murder 56%, assault, grievous bodily harm 80%, robbery with aggravated circumstances 63% reductions. On rape, an 82.8% reduction. And then when it comes to domestic violence cases, he refers to a decrease for the same period. All of these were for the same period last year. A decrease from 21,033 cases in the lockdown in that period in 2019 to 6,651 during the lockdown, a 68.4% reduction. Now, these are reported cases. I mean, obviously, the murders relate to dead bodies with unnatural deaths. So those are more difficult to conceal. But with the rapes, the domestic violence, it depends on people reporting it. Maybe people have not been able to get out during the lockdown, but the sense, well, we still need to look at it. But from those statistics, there's quite a reduction. Obviously, that general reduction in crime will help with the backlogs in the courts. We, I think, need to collect the statistics of new domestic violence protection orders to look at that as well. Just then on Mr. Swart's point, just to stress, all the courts are open. There's no court that is closed. Under level 5, the courts were open from 10 o'clock to 1 o'clock. Under level 4, which we are now in, they've moved to 7:45 in the morning to 4:15 in the afternoon. So the courts are open. Where there is a problem is if there's a COVID positive person who has been in the court, either because they work there and the court needs to be sanitized. And that then can lead in a court being closed. It would seem to be for the most 2 days. I know the regional head in the Western Cape approached the service providers dealing with the sanitization of the courts, who said that I think you can go back immediately for the general wiping, and with the spraying, you've just got to wait a couple of hours. But court staff, including magistrates, have complained that actually in these courts that have been sanitized, that they have experienced headaches and things like that. But the courts are open. It's only when there's been a COVID infection that it might be closed for a day or two. In the case that Honourable Breitenbach referred to of this person who wasn't able to get released, the problem there is as you'd said, corrections not accepting bail money at correctional facilities. The money has to be paid at the court, and then an email is sent through, or a release order is sent through to the facility. The problem with that case that Honourable Breitenbach referred to is that the Bishop Lavis court, where the money had to be paid, was closed on the Monday and the Tuesday. And that's something that I think the acting DG, you need to look at with correctional services. And if courts are closed because of COVID infections, then alternative arrangements need to be made, because as Honourable Breitenbach said, that person sat in custody from Thursday to Wednesday of the following week, which isn't right when he had been given bail. Just one point on the sexual offences courts, which is a new problem for us now, and it's something that the regional court presidents raised. The testifying rooms, the separate testifying rooms, there are now challenges as far as COVID and social distancing. So particularly where you have a child and an intermediary, those rooms tend to be quite small. The child and the intermediary are meant to sit close together. Those are things that we've got to look at. Suggestions of maybe you have a screen. I'm not sure if that would work between the intermediary and the child, but that's just an area that is problematic. Honourable Nevo Drushin's point on sign language. Look, it's got to be an amendment. The President announced the Constitution will be amended. We produce the constitutional amendments, but language is a responsibility of arts and culture. So we need to actually engage with them to actually start introducing this amendment. And because I think the mocking of the sign language interpreters was very regrettable. And I hope, as Honourable Nivo Drushin said, that making it an official language will then make it more elevate it more. There is a risk-adjusted plan on the department's website as to how it's going to work during level 4. Also, just to say that the specific provision in the minister's directions for the Zondo Commission to sit, also the tribunal for the SIU. There may have been an oversight, which we didn't think so, but some of the employees seem to think so, relating to the SIU, which the head of the SIU raised when he was before the committee, but that we will correct. The issues on the National Action Plan, I think if we can attend to those more specifically, I think I'd mentioned last time on Monday that things are going too slow on that, and we need to, or the department needs to engage more on that. On the issue of racism, I think I had covered that on Monday. That the hate crimes, hate speech bill is in Parliament, but it needs the Constitutional Court to make decisions on the Masuku matter and the Kwelane matter. Unfortunately, the Constitutional Court postponed argument on the Kwelane matter sine die to an unspecified date at the request of Mr. Kwelane and the Freedom of Expression Institute. So that unfortunately doesn't help us resolve those questions. Criminal injuria is though still a offence. I think let me leave it like that for now, Chair.
I'm informed that there are 6 questions that were not answered. 6 questions from Honourable Mohammed. Honourable Mohammed, what are those questions?
Yeah, Chair. Thank you, Chair. No, I just wanted to reflect on the one on the infrastructure and the capital budget variance in last year, financially, and this financial year. I also raised the issue of the audit stabilization plan, whether it was signed off, and the impact, whether the asset verification and contingent liability quality were asserted, as well as on the issue of the indicator in the APP, whether the measure, how that will be measured in terms of the backlog plan, whether that's still to be inserted. But I didn't see one. I also raised the issue on the budget, in budget cuts in relation to how will the RAP information technology plan be funded in terms of the replacement of warehouse or offsite storage, as well as submissions, whether there's any procurement in this regard, this happened, as well as on the issue of the IVR, whether 10 in terms of the APP per year is enough. Shouldn't it be 5 times that? If not, why not? Those are some of the questions, Chair, I raised. The other 3 was answered, but these 5 or 6 weren't answered. Thanks.
You can have them written. You can have written responses.
No, Chair,
Honourable
written response is only required if there isn't an answer now.
Oh. Honourable members, I was offline again for a minute or so. So those were the questions, Honourable Mohammed.
Yes, Chair. Maybe
Okay.
there is a response though to come. I don't know.
Yes. Acting DG, can you respond to those questions?
Yes, Honourable Chair, we do have responses. Let me ask our Chief Director of Facilities just to respond on the budget in terms of infrastructure. I will come to the other questions. It's Ms. Gadiaga.
Yes, let's be brief. Let's be brief and straight to the point.
Good afternoon, honorable members. I will respond to the infrastructure questions. The budget, on the slide that was referred to, the budget of 2019-2020, which is 510 million. That budget was the revised or the adjusted budget. The original budget was 900 million, but during the adjustment, because of the challenges that we're living on the ground, some of our projects going through litigation, we had to shift funds. So about 400 million was then shifted to deal with other things. Hence, you see 510. For 2020, 2021, we have that allocation of 800 plus million for infrastructure, and going forward, those numbers are correct. When it comes to day-to-day maintenance, what you see there as 145 million in 1920 financial year, it was after the adjustment. So part of what we took out of the CAPEX budget went to deal with the issues regarding day-to-day maintenance. Hence, that number was sitting at 145, but the original allocation was 70 million. Hence, now when you look at 2020, 2021, it's about 65 million. But as it has been said by some of my colleagues, we are already in the process of the readjustment, and we'll be moving funds about 70 million. That will be moving to the day-to-day maintenance. And part of that is going to deal with the issues regarding COVID-19 compliance, the cleaning compliance that are required, trying to procure booths and getting contractors on site to assist us with the cleaning. So that's how far, that's as far as the budget is concerned on infrastructure.
Okay, Honorable Chair, I'll ask Mr. Priyan Neka just to respond on the IT and.
Good afternoon, Honorable Chairperson and members. In terms of the questions on the e-submission solution, we have developed in-house a solution for the digital submission of memos and letters, and which includes digital signatures. So the procurement of this is part of our day-to-day. There isn't really a procurement process; it's rather part of our day-to-day expenses. In terms of ADR and the number of sites, I think what, as the acting DG indicated, the number is going to be reviewed in terms of the COVID-19. Because when the plan was developed prior to COVID-19, it wasn't anticipated that there will be a bigger requirement for this. But there's also a number of factors that go into determining the number of sites, and those include the volume of cases associated to the prison with regards to remand cases, the infrastructure in terms of the network, because it does require sufficient bandwidth to deal with that. But overall, in terms of the modernization plan, as alluded to in the risk-adjusted plan, we have been tasked to come up with an accelerated modernization plan, which will also include the budgeting required to make that plan implemented. And once it's approved, from EXCO, then there'll be a process of prioritization and budgeting that will take place, and then finalize for implementation. Thank you.
You are on mute, Community Chairperson. You are on mute.
Okay. I'm suggesting, DJ, I'm suggesting that outstanding answers be sent to us in writing. There is going to be an ad hoc meeting, I think on chapter 25. So some of the members would need to leave. So I suggest that we move with speed to the NPA.
Thanks, Chair. We'll do so, and thanks to all of the members. Thanks.
Thank you, Advocate Batuli.
Thank you very much, Chair. Chair, I will commence, and then some of my colleagues will deal with some of the questions. The first questions that we were asked related to the fact that the impact of COVID on the NPA, and how were we going to address this in light of the fact that this has not been addressed in our strategic plan, which was developed prior to COVID. Chair, we have within the NPA, we have set up a COVID-19 task team, and this group is set up it comprises various disciplines within the office. So it looks at the operations, it comprises the communications section, the HR, IPSO, which is the innovation and policy section, and so it deals in a holistic way with the NPA response to COVID, and they have, in fact, they are, in addition to our engagements with the Department of Justice in terms of managing the impact of COVID on the courts and the prosecutors. This group is now looking at what possible impact there could be on the services in the courts relating to prosecutors in particular, as we move towards the peak in July or August, as it is predicted. And so this is a task team that has a very comprehensive and holistic approach, and is planning in terms of the role of the NPA and how we could address the various challenges that the organization will be facing in the light of COVID, together with our role players, of course. But they are also looking at the role of the prosecutors during COVID, and in particular also looking at respect for the rule of law. And one or two of the members, in fact, I think it was one member that alluded to the fact that there have been some allegations of heavy-handed or abuse by our law enforcement authorities. In as much as we work very closely with our law enforcement authorities and we partners, and we need to work closely, we also need to hold each other accountable. And so wherever there are these instances of overzealous action, for want of a better word, on the part of law enforcement, we as prosecutors will do everything possible to ensure that the rule of law stands supreme and that these cases are dealt with efficiently. There was a question relating to that about what the prosecutors would do to fast track the investigations in such matters. In this particular case that was referred to, it was it wasn't the police, in which case IPID would investigate. I think it was the Department of Defense, and so investigations would be by SAPs. And so generally the prosecutors, and I think it's really important to understand, because very often when things are not moving in investigation phases, the NPA is asked, what are you doing about it? And I want to be very clear about this. Besides the directorate, which is totally separate, the NPA is not the investigative authority. We work with our colleagues in law enforcement, and where cases are particularly complex, we do then provide prosecutor-guided investigations. But law enforcement must be held accountable for efficient and effective and fast investigations and bring the dockets through to us. These are relatively simple cases, depending on the facts, of course. But only when it's complex does the NPA play a role in guiding. But otherwise, the NPA is not the investigating authority. And I think it's really important to make that point. With regard to the questions, the first questions that were asked about the review, has a review been conducted on the achievement of targets? We have done an assessment of the various targets, the 2014-2019, that's the previous 5-year strategic period, that were not achieved. And they relate to, well, they are the following. That is, firstly, it's the conviction rate in respect of trio crimes, and trio crimes are armed robbery, housebreaking, business and residential, and car hijacking. And this is, there are various reasons that the NPA has actually There are various reasons why we did not meet these targets, and many of them relate to insufficient investigations, and so this is one of those so-called quality of life crimes. If people feel they don't want to be attacked, you stay in your home. But when you are attacked in your house, it's where people really feel that their security has been violated in such a bad way. And that is one of those quality of life crimes that really make people feel unsafe. And so, Honorable Breitenbach also asked, how are we going to achieve these really fantastic high-level outcomes that we've put in our plan? Let me firstly say, those are very ambitious outcomes. People feeling safer, investor confidence being improved, and so people haven't felt safer in South Africa for years. So this is a very, very ambitious target. It's an impact target, because as other members have alluded to, we simply don't want to continue doing work without really making an impact. So with regard to people's feeling of safety, we feel that if together with our partners in SAPS, we can target certain crime types very, very strategically, like, for example, housebreaking. They say 80% of housebreakings are committed by 20% of housebreakers. So if we have some kind of a strategy to target the 20% in a very, very carefully thought through plan and hold each other accountable, we can try to enhance people's feelings of safety. So that's how we want to be strategic in our prosecutions and not just simply prosecute because cases are before the courts. It may well in this process mean that some other cases may not be prioritized, but it's something we will have to discuss with our partners and look at, because we do have a victim-centered approach. And every victim generally wants their day in court. So it's going to have pros and cons, but if we can show real value in the approach we're taking, I think that will go a long way to try to address issues of people's feelings of safety. And the question also talked to, how are we going to, we have this our impact statement of people being compliant with the law. A culture of compliance. That is not going to be easy by any stretch of the imagination. But we want to, and yes, it is so that if we prosecute and the more that, we get conviction rates and people see that cases, they say that the greatest deterrent to crime is the certainty that cases will be investigated properly, they will be prosecuted properly, and there will be consequences. And so, we have to ensure that is what happens together across the entire JCPS. And there are various initiatives with our partners to try to address these issues. And then the question that related to, the fact that, not a single high-profile case has been enrolled, that is not factually correct. There have been one or two. But these things get forgotten very quickly as well. And I'm not saying that those cases, we should, there's a lot of work to be done in this space. And yes, so I'm going to leave, Advocate Cronje will touch a little bit on that, on some of the issues that they're dealing with, but bearing in mind that this is a strategic session where we are forward looking, it's not reporting on what we have been doing. And so, I would thank you very much, Honorable Janches, I see you agree with that. So, but what I do want to say is that we will report on this, and they're huge. People must really still understand that we are still operating in a very, very inefficient system. And they are, but the good thing now is that there are plans in place to address these inefficiencies, and things are not going to change overnight. If we want to really deal with corruption properly, we need to ensure that we actually develop a system that is able to, with the right capabilities, with the right types of skills, and I'm not just talking about human resource capabilities. You talk about cyber forensic capabilities, and there's the list, I can really set it out. But so we are wanting to build a system that will be able to respond very effectively to these types of crimes. And at the end of the day, South Africans can truly be proud of during this 5-year strategic period. The issue of, what are we doing about, prosecutors or how to clean up the NPA? Again, this is a strategic session, but it's a valid question. And, there've been various allegations in the public space. And, there's been, the process has been particularly complicated because, it's not just one person. The allegations are not just against one or two people. The allegations against several NPA staff members. And one has to really look at it in a way that addresses this matter holistically. And perhaps the other complication has been that the Zondo Commission is also looking at capture in the law enforcement stream. And certainly in the NPA, it would be unwise to have a process that runs parallel to the Zondo Commission process. But we are engaging with each other to ensure that, we can deal with this matter effectively, because I agree with you that it is something that needs to be done. It must be done fairly. It must be done transparently. The issue of technology and fast-tracking technology, I cannot overemphasize the importance of technology, and my colleagues in the department have spoken about it, but we are shooting in the dark if we don't utilize technology and data to properly drive our decision-making. And so the IJS system, which has been one of those unfortunately massive failures of the system, is now a priority. It has also been identified as a priority in the economic recovery strategy of the JCPS. And there is a strong commitment now to, I know the department has hired new people in this space. The minister is really supporting this. And from the NPA perspective, as you heard when Hanneke van Zyl presented the budget, we have procured laptops for prosecutors. The ECMS system, which is the electronic case management system, which is the NPA part of the broader IJS, is something that has been identified to be a top priority, and it is in the NPS plan, in the NPA plan, as well as in the NPS plan, in terms of really pushing with this, because without, we have tons of data in government. We're just not analyzing it properly, and we're not using it to properly prioritize, to identify projects, etc. So the issue of technology is certainly very, very high on the list of priorities, and it is part of our plans. The issue of the president speaking about units in the NPA that will deal with corruption during COVID. This matter is being dealt with, as I alluded to in my opening remarks, by the JCPS cluster, because it has to be a coordinated response to this. And I'm really quite excited about the Fusion Center concept. And it's not just the Fusion Center initiative, should I say, where the NPA, the DPCI, the FIC, SARS, the SIU, and key components in the law enforcement space have come together to and will be co-located at national in order to ensure that all matters relating to COVID, corruption and other related matters during corruption will be dealt with in a very coordinated way at national, but ensuring that where these incidents happen in the regions, there will be monitoring of how these matters are being investigated to ensure that there is a speedy response to this, so that there is a deterrent factor when it comes to these particular issues. So I'm really excited about this project, and hopefully, one will see the fruits of this in the coming weeks. But the important thing is that we need to do it right and focus on that for now. The issue of the arrest of the prosecutor in Limpopo, Yes, I think we'd be fooling ourselves if we thought that that is the only issue. I certainly hope that there is a very small percentage, worst case scenario of prosecutors that are inclined that way. But we have, in fact, put in place one of the issues that I also mentioned in my opening remarks was the creation of the Office of Complaints and Ethics, which is provided for in the National Prosecuting Authority Act. And we are looking to actually ensure, and I've spoken to the minister about this as well, we are looking to ensure that this is put into place as one of those initiatives. But pending that, there's a number of initiatives relating to integrity issues, for example, dealing with enhanced vetting, lifestyle audits. Lifestyle audits is something that I know the DPSA is looking at lifestyle audits across the entire public service, which I think is an excellent intervention that is long overdue. But within the NPA, I have already given an instruction out that this be done with regard to the starting with myself, with regard to all the top level senior managers, all the heads of units, our security and risk and our integrity management sections, that this must be done to start off with. So that's just one of the initiatives that we are looking at to ensure that there's integrity in the organization, which is a big part of building credibility. The issue of lessons learned in terms of, sorry, I can't read my own handwriting here. If you can just guide me in terms of what that question is, please, colleagues. The issue of, I think I missed out the review. I actually started off the review. Have we done a review of the targets? And that was the first. I just realized, Honorable Breitenbach, I didn't. The trio crimes I touched on, that was the one, but we also didn't meet targets relating to number of persons convicted of corruption, where the amount involved is more than 5 million. Number of government officials convicted for corruption or related offences, where the target was missed by 9%. The finalization rate. So if you just deal with the corruption issues, I think I can really say without any fear of contradiction that this was not dealt with for a couple of reasons. One is, I think there was no real will to deal with some of the very, very high level corruption matters, which we are addressing now in the Directorate, but also in the National Prosecution Service, where Advocate de Kock, who is now here, is liaising very closely with the DPCI, and right from October last year, when we had our strategic planning sessions, we also had an NPA anti-corruption session where DPPs were required to identify high-profile corruption matters in their space in order to ensure that we could prioritize them and make sure they get onto the rolls quickly. And of those, the DPCI also identified, I think there's 80 odd cases. I don't have my notes here, but of those numbers, 16 of those cases have been placed on the roll. And so that is quite significant when one looks at it in the space of 5 months, but I don't have the details of those cases, but I'd be certainly happy to make them available. But they are, so dealing with corruption, one is we have the Investigating Directorate, which is addressing some of the issues, but capacitation of the Directorate is a huge challenge. And I've spoken to the Minister about that, and we are looking at 1 year down the line what we can do to enhance that. But be that as it may, within the NPS space, we are looking at, within the NPS space, we are looking at very close collaboration with the DPCI. In addition, I mean, the ACTT, I didn't say it was disbanded. It is something that, well, it was, it was hugely inefficient, to say the least, in dealing with corruption matters. But now there is, in the ACTT, between all of the role players, General Labia as well, myself, there are plans and initiatives to ensure that all these matters are properly addressed, and prioritization is one of the key issues that we're looking at, because the amount of work is so much that if we don't prioritize, we will never be able to have any impact. So oh, sorry, and I think Advocate de Kock will also add some lines on that, because he's been working very, very closely on this particular issue. But yes, that was regarded as one of the big targets that were not met in the previous period. Dealing with allegations of racism and favoritism, nepotism, etc. in the NPA. With regard to this, there was an advocate that has been appointed to do a fact-finding into this matter, and his investigations have commenced. So we look forward to his report and certainly recommendations on how this can be addressed. It is a very serious issue, and we take it very seriously in the NPA, and I'm hoping that out of this we will be able to address many of the concerns that have been raised. We do want to be an employer of choice, and so it's important that we address these issues. The issue of Honorable Janshi, I'm very pleased that you are happy that the plans are now coming to fruition. I'm not sure if you've seen the 5-year strategic plan of the NPA. We understand it should have been tabled in Parliament, and we are not. There seems to be a lack of, because our plan falls in with the Department of Justice. So the Department of Justice submits, and they have a little bit about the NPA, but we do have our 5-year strategic plan, which I think we should actually share with honorable members, so that you can see that the plan is not just emerging, that it's there and at the different levels. But in addition, as I said, to the strategic plan, we have in parallel to that a plan that is going to take the NPA to being an independent, professional, accountable and credible institution. We take your point about the 5th pillar. Just to explain that effective prosecutions, I mean, that is the core business of the NPA, and it's hugely important. But the pillars were meant to underpin the broader strategy. And so effective, in fact, if you look at those pillars effective prosecutions would cut across all of them. And so, we want to be independent, and that means we must prosecute effectively without fear, favor, or prejudice, without any political interference, or without any external interference at all. And there was a question from one, I think it may have been Honorable Ngola, about whether there has been any interference in the work of the NPA. And I can say absolutely categorically that there has been no interference at all in the work of the NPA. We will continue to do what we have to do. We will do it right. It is sometimes not as fast as people would like to, but it's hugely important that we get things right. The issue of, I know you made some comments, and we appreciate the hard and the soft approach. We're here to take them both and to learn and to actually improve how we do things. The quality issue versus the conviction rate. There was a question, I think it was also Honorable Ngola that asked that question. This was something, yes, that the Chief Justice did mention at one of his public addresses, about the fact that the NPA has, as one of its measures, conviction rates. Let me firstly say that a measure of the performance of prosecuting authorities, conviction rates being a measure of performance, is something that is in many internationally, in many prosecuting authorities, this is in fact regarded as a measure of performance of the prosecuting authority. That said, I agree completely that it cannot be the only measure. And so, at the end of the day, prosecutors actually, we want to see justice done. And we want to ensure that is our primary, we want to assist the court in coming to a just outcome. And so justice is hugely, it's not conviction at all costs. And so, but what are we doing when there are allegations of criminality? The police are investigating it. We want to make sure that there are consequences. And so we work really hard when we are of the view that the evidence points towards responsibility or accountability, that we must actually pursue it. And so we guide the investigators, we work with them in complex cases with the aim of actually ensuring that there is accountability. And if that means a conviction rate, then that's part of it. So I think it's really important that we understand that in as much as we are certainly, I mean, not the only ones that contribute to this, but the prosecutors, in fact, play a significant role in that process. The issue of conviction rates, the issue of the mitigating actions. Honorable Janshis, I alluded to this at the outset as well, and didn't deal with it because of time constraints. And I agree that our presentation should have included our mitigation plans. But unfortunately, the presentation was already submitted to Parliament, and we didn't want to change it in case it caused confusion. But we do have, and each one of them, for example, the first risk is the negative public perception and reputation of the NPA. This was a huge risk, and we know that this is what the NPA has labored under for the past couple of years. And so some of the mechanisms that we've put in place to deal with this, and I'm going to deal with this question also I'm also going to address the question raised by one of the honorable members relating to credibility and what has been done to enhance the credibility of the NPA in the time that I have been in office. This is, as it's one of the pillars, as you can see, of the NPA. Credibility is one of them. So it's hugely important that the public trust the NPA, and that we deal with our partners, that they trust us, and that we are honest. And there are so many different aspects that talk to credibility. So I'm going to actually deal with some of the issues that talk to the credibility issue. And achieving a credible organization is not an event. It is something that we need to be working on constantly. And that is part of our strategic plan, is to make sure that we achieve a credible organization. And in dealing with some of these risks, it will talk to what some of those initiatives that we have to achieve that credible organization, because it does reflect on our reputation as the NPA. So we're looking at the Office of Complaints and Ethics, which is the one issue dealing with the negative public perception. We are setting up a donor oversight mechanism, because that is also something that's come up that's impacted on the credibility of the organization. And I can give a lot more details about all of these issues. We are looking at, with regard to the perception issues, we are looking at, I talked about the lifestyle audits, the integrity testing. I talked about the training of the senior leadership, and I'll touch on that about why we are engaging abroad as well as internally. Some of the other mitigating initiatives in this regard is, for example, a transparent and deliberative appointment process for the NDPP. And you know, that is something that we are working together with the Department of Justice in those kinds of initiatives. Communication strategy is part of our mitigation plan. We want improved communications with the victims of crime, and we want to engage with them more. We must be a trusted partner, and therefore Advocate de Kock talked about the Community Prosecutions Initiative, and that is meant to build more trust and confidence in the NPA with the people that we serve with humility. And then I talked about strategic and smart prosecutions. Hopefully that will talk to issues of safety, and all of the last ones that I talked about, the last 4 of them, will talk to credibility issues as well, in terms of building the credibility of the institution. The second risk was inadequate stakeholder management and effective coordination. There are various initiatives in this regard. Firstly, we are engaging with, maybe I should premise this by saying that the JCPS cluster is where stakeholder coordination happens at the highest level. And so that, we need to really be bold in the JCPS and make very bold decisions in terms of how we are going to hold partners accountable. So the the task team that's been put together to look at efficiency and governance in the JCPS is certainly going to address this risk of inadequate stakeholder management and effective coordination. But at different levels, there are various interventions that we are putting in place. We are engaging with SAPS to look at joint measures for the first time. We are saying to SAPS, when you arrest, that does not mean the end. You can tick your box and say, I've achieved. And then it's about moving it beyond that. So we're looking at joint measures with SAPS, which will address this as one of the mitigating measures. We are looking at dealing with, there's a National Efficiency Enhancement Committee, which is chaired by the Chief Justice, and there are also provincial efficiency enhancing committees. But I think one really needs to look at the efficiency of these committees themselves, and we really need to look at how we can enhance the efficiency of these committees, because the management of courts and all of us play a role in it, but the judiciary does lead that aspect. And so, we still have extremely low court hours. I think it's now well under 3 hours. And so moving, when one talks about the backlogs and going, into COVID and it's going to be worse, we got to start off by saying, how do we ensure that the courts sit the 4 hours, 30 minutes that we meant to be sitting? And so we need to be we are engaging with our stakeholders in that regard. And so those are some of the mitigating measures for the inadequate stakeholder management. Insufficient use of technology, I think I've touched on that in my earlier response. Lack of skills and capacity to attend to complex, that's the last risk that high-level risk we've identified. We are looking at an NPA recruitment and retention strategy, not retrenchment strategy. Recruitment and retention strategy. The IPSO, which is an Innovation and Policy Support Office in my office, together with our HR, is working very closely on looking at a whole professional development and training strategy. We are working with other external stakeholders as well that are willing to assist us in this regard. We are looking now during COVID at web-based trainings, and COVID has really pushed the boundaries in terms of us really looking at how we can do things better in this time and utilize technology to do this better. And this includes training for prosecutors. And so, those are some of the mitigation measures that are in place, Honorable Janchis. And then the issue of, let me just go, the chair then asked 3 questions. The third one related to the NPA, and that relates to the training. Chair, I agree. Training. We must look at our institutions in South Africa, and we have a lot of capabilities. This training is a joint venture between the University of Cape Town and Oxford University. Whether it happens now, I don't know, because of COVID. And this was going to be, we were seeking donor funding for this. So it was not going to be paid for from the NPA budget, but it was going to be, and I think the idea of Oxford as well was a bit of, for our own NPA staff, was a bit of prestige and recognition for the senior leadership for the work that they've been doing. And I think, is some kind of motivation, but it's a joint venture between the University of Cape Town and Oxford University, where we have a very strong relationship with the professor who is the head of the ethics institute there. And so, we certainly hope that this will be able to, we will still be able to proceed with this, given that we are now faced with COVID, but we are still keen to start with this in September. We may not be able to travel to Oxford, but certainly, hopefully the training will be conducted. And this will really, I think, Chair, to really emphasize that if you have your top leadership that goes through a tailor-made leadership training for the NPA, we are looking at setting up a senior management with the right skills to take the NPA in this new direction that we want to take it. So this is a really important initiative for us, and hopefully we'll get the funding for it as well. Chair, I'm going to leave it at that. I'm going to hand over to Advocate de Kock to deal with a couple of issues, and if there's anything left at the end, you can come back to me. Thank you, Chair. May I hand over to Advocate de Kock, please?
Sure.
Thank you, Chair.
Thank you, NDPP. Thank you, Chair. I'm just going to deal with the question around the decision dockets in relation to the lock.
Sorry, Advocate de Kock. I know that you are very passionate, but try to be brief.
Thank you, Chair. I'll be very brief.
Chair, it's not fair, Chair, because you allowed the Department of Justice a lot of time. No, it's fine. We will try to accommodate, Chair, certainly. Advocate de Kock, that's an instruction. Thank you. Please go ahead.
Chair, my colleagues in the MPA know that I'm not a man of many words. So I won't be, I don't talk much, but I do a lot. So just in relation to the issue around the decision dockets and the lockdown offences, the MPA is very sensitive about the manner in which we deal with these matters. So we agree. You don't want to criminalize the country. As we speak, based on the number of decision dockets that we've received, 25% of those dockets have not been enrolled, which are dockets where prosecutors have made a decision not to prosecute. So it means that prosecutors are being fair, they're evaluating the matters carefully, and they're dealing with these matters subject to the Constitution and the law. And that will be our approach. All members of public are free to make representations in their matters, and those representations will be taken into account. So that is the approach that we are following. In the majority of these offences, the members of the public have been given notices to appear in court in the future, and so those cases will still come to the courts as we deal with them in the future. So that will be our approach. Regarding the issue of the inconsistent way in which the prosecution measures its performance, I think the NDPP spoke about the conviction rate, which we all agree. And after intense discussions in the MPA, we agreed it must remain. But what we have done is we've introduced a balance in terms of how we want to measure our performance. And we now have a basket of measures that we take into account. So it is important for us to understand the percentage of cases enrolled. When we talk about corruption cases, we want to know how many priority corruption cases are there and what percentage of those cases have been enrolled. So that's just an example. We will link it then to the conviction rate. So if we say we want to enroll 40% of corruption cases in a given year, we want to then ensure a 93% conviction rate in those cases. So that's going to be the link in terms of how the prosecution approaches that. The third area in terms of the basket is the quality indicators. And then we're looking at surveys, which is also a new way of doing business, to ensure how do we make sure that the prosecutors are doing their work properly. So that is an independent evaluation of the work of the prosecution. So it's a basket of indicators, a basket of measures, and hopefully this is going to contribute to an improvement in the performance of the prosecution. There was a question about the lessons learned from our failures of the past. I think our strategic response that the NDPP has set out is a response to the failures of the past. So that's the first point. And we've developed the risk mitigation plans as a response to that. But I think there are 5 key areas that we will look at. The one is modernization. The 2 is enhanced stakeholder cooperation. Thirdly, the sharing of information with our stakeholders, and particularly with the police and the DPCI. So here, for example, we are looking at a common database. We are looking at even giving the DPCI access to that common database so that we have a list of top priority cases within the prosecution service that we are all working on. Then we're looking at the alignment of our targets and joint target setting so that we work towards common indicators as the DPCI in particular with the prosecutors. And then lastly, in order to enhance the quality of the work that we do, we must ensure that there's sufficient resources. So that is what we are doing with the police. The police must ensure the quality of the investigators are correct, the number of investigators are correct. The prosecutors must ensure that particularly in the corruption space where we have the SCCU, that we have sufficient prosecutors to prosecute. And so what we are doing there is we're increasing the numbers, but we're reducing the workload. And so we've decided some of those cases are going to go to the directors of prosecution to deal with in the general prosecution space, and the rest of the top priority work is going to be done by those prosecutors who are trained and skilled to do it. As we go along, we will look at enhancing the capacity through further development of those prosecutors. The NDPP is very keen that we do that. The next issue related to the COVID-19 funds and our response to that. The NDPP has spoken briefly about that in the introduction, but what we've done is we've created at the Fusion Center under the leadership of the FIC, because the Fusion Center is based at the FIC, the Financial Intelligence Center. We've created a dedicated group of people from the following agencies: the FIC, the SAPS Detective Services, the DPCI, the SIU, the SARS, the MPA, and our intelligence agencies. And we're looking at an intelligence-based approach. So as we speak, we must be able to analyze what is happening with procurement, what is happening with the funds that's been allocated. Are there any indicators that people are misappropriating or abusing the money that's been allocated for the COVID-19 initiative? And so that is the approach. People will meet on a daily basis, do the analysis. If we find that there's criminality, investigations will be initiated, and flowing from that investigations, prosecutions will be initiated in our various regions of our directors of public prosecutions. I think lastly, in relation to the delay in prosecution of corruption matters, that are older than 10 years. Again, as I've indicated, some of the initiatives that we have already engaged with, closer cooperation with the DPCI, engagement at a very high level. Some of the issues that we've identified is long outstanding forensic reports. We are working to improve that. We are looking to build a capacity within the state to be able to do the forensic analysis. And I'm sure the ID and Advocate Cronje will also maybe just speak a little bit about that particular challenge. We will set aside sufficient budget to be able to pay for the forensic analysts to come to courts, to come and give evidence, and of course to finalize the reports. The closer working relationship with the DPCI on all priority cases, having the common database, as I've indicated, and to ensure that the resourcing is there for us to be able to do the work. So that is going to be our approach going forward. And it's also then finally linked to dedicated courts. And I think the department has spoken about the SCCU courts. And so we're looking to have more of the SCCU courts so that we can take the corruption matters to these dedicated courts. That in brief is the further inputs from my side. Thank you very much, Chair.
Thank you very much.
Sorry, just one thing. There were some questions on the GBV, and my colleague from the soccer unit, Advocate Piers Smith, who's the acting special director of the soccer unit, is just going to answer 2 further questions, but he'll be quick as well.
Good afternoon, Chair and honourable members. Thank you for the opportunity. I will deal with the questions quite swiftly, as hopefully I would. In relation to the questions that were raised by the honourable members for the emergency reaction plan update, It needs to be noted that the NPA participated in this process in a comprehensive manner in relation to certain activities for which we provided a detailed report to the Department of Women and the Ministry in this regard. This report is quite elaborate and can be made available to the Honourable Committee for members so that it can be shared for inputs in that regard. In relation to the question for backlogs of DNA outstanding reports, we have already kick-started a process with our DPP colleagues in relation to identify DNA backlog cases in sexual offences, where those cases are to be prioritized with the forensic laboratory in relation with SAPS. So we work quite closely with them. We have identified already 235 cases in 6 divisions that we prioritize towards the National Commissioner in that regard, for National Commissioner of SAPS for his assistance, so that those cases can be fast-tracked once those reports are made available. The other question that was raised by Honourable Member Horn in relation to the targets and numbers, I just want to add on what my supervisors already indicated. It must be noted, as the NDPP correctly stated, that conviction rate is an international accepted target in relation to the measurement of quality performance, volume of matters dealt with, and also progressive planning forward. But this, together with your actual numbers, is a clear indication from the NPA side how we can collectively enhance ultimately our victim-centric services, which honourable members would have noticed is part of the NPA outputs as reflected on slide 10. In relation to the increase in GBV cases that were noted by the call centres, the Honourable Deputy Minister also provided feedback in that regard. In addition to that, I would like to state the following, that once an analysis was done by myself in relation to matters reported at the TCCs for the month of April, specifically in comparison to April 2019, we've realised there was a 51.9% decrease in matters being reported at the TCCs. That was, in fact, 1,497 less matters in April 2020 than what it was in April 2019. However, it should be noted that under the lockdown processes, it's understandable because it impacted on the movability of people. We have also indicated to the call centre, as the rule is, that once people are calling in, and wanted information about processes, that these matters should ideally be reported to SAPS or TCC matters so that it can be investigated and taken forward in that regard. In relation to the SUBV backlog cases, it was also dealt by my colleagues. Those cases are a priority, as many of the other matters are. And once the lockdown is to be lifted, those cases will be prioritized, as the position is now currently with our DPPs as well. It's been included in the NPA and APP plans as well to be taken forward so that these cases can be dealt with as a priority. Thank you. That's the end of my inputs. Thank you.
Thank you very much, Advocate Fock and Advocate Smith. Chair, if I may, just on the TCC issue, Tutuzela Care Centres, one of the initiatives that we are also looking to implement in this period is a national coordinating structure with regard to the TCCs, which at the moment does not exist. That will ensure that we are able to, at a national level, coordinate and to ensure that various sites, the TCC sites, are properly managed and properly resourced, and that there is a central coordination mechanism. That's something that we hope to also, and the NPA is also looking to develop sexual and gender-based crimes policy that will guide our work in this regard. Thank you, Chair. I'm not sure if we have left out any questions. We can be directed to answer them, Chair.
Advocate Green, you said Advocate Green is going to answer some questions.
Chair, she can certainly do that. I wasn't sure whether it was necessary that she does, but perhaps I can just hand over to her, because as we said, this is a strategic session, but I think she can certainly allude to some of the issues that they are dealing with and some of the cases. Thank you, to the extent that she can.
Good afternoon, Chair. Can you hear me?
Yes, can hear.
Chairperson, there were a number of questions, and I don't know how much time we have, but just to say on the strategic plan, the Directorate's targets for the next, the remaining 4 years, because Chair, yesterday was the first anniversary of my appointment. Needless to say, there wasn't much celebration, but just hard work to carry on delivering on what is expected of us. I suppose the one thing to say is that it's not true that nothing has happened. We have certainly, in the 3 focus areas that the IB has been working in, firstly, the area of the security sector, we, working with the National Commissioner, have focused on prosecutions involving senior members of the South African Police Service who are still sitting, who are still employed by SAPS. And we have a number of those prosecutions on the court rolls. So we've got before court a former acting National Commissioner, we have before court a former provincial commissioner, and about 8 generals relating to mainly contracts that have been awarded in the supply chain management process of SAPS. So those matters are before court and will be in the following week or 2. Those matters will be back before court, and I think the public will get more of a sense of what is involved in those prosecutions. In the public private sector corruption space, I've said before that there are 2 major cases that we have dealt with there, the Bosasa matter and the Estina matter. The Bosasa matter is before court. There are 4 accused before court. We have been involved in arrangements to bring the first suspect who is abroad before court. That has been impacted obviously by COVID-19 in that the person needs to travel to South Africa. The investigation into the second phase of the investigation, which is into the allegations that emerged at the Zondo Commission. There too, a number of prosecutions are ready to be instituted. 2 were meant to be instituted during this period. While the courts are open and we are ready to approach the courts, there are logistical issues that have made them difficult. But as we move to more eased COVID-19 restrictions, we will be able to put back on the roll, or put on the roll, the matters that we have prepared and have ready. On the Estina, there was a specific question around how mutual legal assistance is proceeding. And a number of our matters involve mutual legal assistance and involve cooperation with our counterparts abroad. And there was also a question about how are we faring getting our money back to South Africa. In the Estina matter specifically, we have received, with the assistance of the executive, some cooperation. And it has certainly had an impact on the scope of the charges and the scope of the accused persons that we are intending to bring to court. But we are still awaiting further assistance from the UAE. Assistance has been promised, and we've had a first installment. We are waiting further installments, but we are also at an advanced stage in procuring alternative evidence. Because just to quickly assure members that we are not looking at, there's lots of clamor, can we please just do the low-hanging fruit? The problem with low-hanging fruit is that they will cause grave dissatisfaction if lower level officials are targeted and we don't get to the people we were set up to get at. But to get at those people, in other words, the people that don't have their hands dirty in the award of contracts, but the people who are benefiting and orchestrating behind the scenes, there are critical pieces of evidence you need. Cell phone communications, email communications, and obviously bank statements and following the money all around the world. And And so that is why the cooperation and the assistance from the UAE has been so critical to us. And now that we've had a measure of that evidence made available to us, we are determined, and again with the cooperation and assistance of the executive, to get the evidence we need so that we have the full scope of those who were responsible in that matter before court. But the same goes for a number of our prosecutions in the SOE space. You'll recall in December there were arrests of what people would call low-hanging fruit. But those arrests do not address the people we believe are most responsible for what happened in the SOEs, and we are dealing with those. We have before court in the Transnet matter a freezing order for 1.5 billion rand, in which the matter will be argued next week in court on an opposed basis. But in that hearing too, there'll be an understanding of what is at stake. And I had actually prepared a slide presentation, and in one of the slides I did want to show the committee that we were presented by a multinational who we are looking at as a potential suspect, present to us the investigation that they had done to exonerate themselves, obviously. But I said to them, if I ever am asked to be before Parliament, I will share what they shared with us, which is the fact that they had conducted an investigation into one of their officials that involved, as they informed us, a top New York and Washington-based law firm with a leading South African set of attorneys. They looked at 9 million documents. Over 39 million pages, they told us. 800 search terms were applied, resulting in 1 million dockets being reviewed. So over 4.3 million pages. They say they did end-to-end linear reviews of emails of the suspected executive and other data totaling more than 300,000 documents. 30 to 65 document reviewers, that is human beings, attorneys, 30 to 65 at various points looked at the documentation that resulted from searches. And then they conducted more than 115 interviews of over 60 individuals and contracted a third-party forensics review process. And that is one suspect in a prosecution involving a number of other suspects who colluded to loot from the South African government vast sums of money. So I won't go into what we have at our disposal in that matter, but certainly that we have plans, as you asked, in place to ensure that we upscale, not nearly to that extent, but significantly upscale our capability to be able to finalize our investigations and make sure that we get those most responsible. That's really all I have to say for now.
Thank you, Advocate Cronje. Thank you, Chair. That is the NPA responses. If there's anything further, we await to be directed.
No, thank you very much. Honorable members, I'm aware that you have written to me that some of your questions have not been answered, especially questions directed to the Department of Justice, Honorable Glenis Breitenbach, Honorable Swart, Honorable Mohammed. We will ensure that our Secretariat interacts with the Department of Justice so that we can get those responses in writing. I will now hand over to the Deputy Minister if he wants to wrap up.
Chair, thank you. Yeah, I think we're covered. So I've got nothing more to say, but thanks for the engagement.
No, thank you very much. This was a very fruitful engagement with both the NPA and the Department of Justice. I think as a committee we would like to interact more with the Solicitor General, especially with regard to the briefing patterns. And one of the problems that lawyers are raising, especially those who are practicing at the bar, it's not being paid on time. So we would want to find an appropriate time where we would interact in more detail with the Solicitor General. And the other issue that we have picked up is that we want stability in the Department of Justice. We cannot have a department that has an acting DG, acting head of corporate services, acting chief financial officer, chief director, strategy, monitoring and evaluations. We really need stability. I think when you come back in October, we should not be having these posts unfilled. Because in my little experience in government, once you have a high level of instability at a level of senior management, the next thing that happens is that most of the targets will not be fulfilled. So as one issue that we think as a committee, we want something tangible, that when you come back in October, all those positions need to be filled. We know that there are positions that are within your control, DG, and there are positions that are within the control of cabinet, like DDGs going upwards, chief directors going upward, downwards. Those positions need to be filled. And DM, please press, we would like you and the minister to ensure that when we come back in October, we have a DG. We also note the good plans by the NPAs, by the NPA. We are happy to see that there is good work that is being done there. And we also note that there is a lot of work that the Department of Justice is doing, a lot of good work, but we do think that we need the leadership of the department to be stable. We would like to interact with the NPA more on the risks that have been identified going forward. NDPP, as you have already alluded to, we would appreciate if this investigation on racism can be expedited. We are getting these letters almost on a weekly basis. So I think if that investigation can be concluded.
Chair, I'm sorry, that was unclear. If you could please repeat the investigation that you're referring to. Is it the prosecutor in the Limpopo matter or the racism allegations?
The racism allegations, yes.
Oh, sure.
If they can be concluded as soon as possible. We also need finality on the integrated justice system. We can't have a project that spans over a decade. We just we want to conclude this matter. We appreciate the fact that the Department of Justice has somebody dedicated on this issue, seconded to it. But I think one of his main target is to ensure that this matter is concluded. We are also quite excited about the fact that you have identified a need for a uniform policy on the issues of language interpreters. We think that is a very good observation, and we think that it needs to be followed up, that issue of unified processes. in acquiring the services of language interpreters. We need a uniform approach, because part of the problem with us in government is that we seem to behave as if we are 34 republics as departments under one government. So we must ensure that as government we have a unified policy on that score. And we would also appreciate a situation where there is a sharing of good practices. The Department of Justice is struggling to achieve a clean audit. But on the other hand, you have the Legal Aid South Africa having 16 years experience of achieving clean audits. We think that there needs to be a sharing of experiences. How did a Legal Aid Board be in a position where they are able to achieve 16 years of clean audits? And the Department of Justice has challenge on that score. We think that we need to have those conversations within the justice family. I think one thing that is clear now, even the IT system, the NPA's IT system is very audible. On the other side, we're struggling to hear the Department of Justice. We need a sharing of those particular experiences within the family. But we are really encouraged to see that a lot is happening. I think we're seeing a lot of energy under your leadership, DG, acting DG. There is a lot of energy that you are infusing into the department, and we really do appreciate that. But we have set ourselves targets to say, by the time we reach 2024 and our term comes to an end, one, we do not want to leave a situation where we do not have an integrated justice system. We do not want to have any of our entities or departments reporting to us not achieving a clean audit. I mean, if that happens, we would have failed. And if we fail, it will be difficult for us to recommend that you get bonuses when you have not achieved some of these things that are basic. I don't think that there is anything difficult in hiring people. We cannot accept a situation where a department reaches 22.6% vacancy rate. It's unacceptable. It's unacceptable. So no, thank you very much. We will interact going forward. As the NDPP was always reminding us that this is not a session to report back, which is a good, it's a good observation. But we think that when that session comes, there are things that we do not want to hear. We do not want to hear a high vacancy rate. So, honorable members, Deputy Minister, Acting DG, and DPP, thank you very much. I think
thank you, Chair.
We will leave it at that because there are some members who must attend the Section 25 committee that is starting soon. Thank you very much.
Thank you very much, Chair, for the positive engagement, and we look forward to further engagements in the future. Thank you.
Thank you very much.
Thank you, Chair. Tell them we'll watch the space.
Thank you, Chair.
Thank you.
Thank you, Chairperson.
Thank you.
Thank you, Chair. Thank you, members.
So, thank you. Thank you.